By the time it's all said and done, you will see who is the mass murderer.
What's going on, y'all? Attorney Tom here. Today I'm going to be reacting to the opening statements in the trial of Ronnie O'Neal. This is a real trial, unlike the trial of Tim Heidecker. But similar to the trial of Tim Heidecker, the defendant is representing himself. The defendant is going pro se, which is a terrible idea. It is always a terrible idea. And this is especially true in a criminal case. The founders of our country gave us the Fifth Amendment right to avoid self-incrimination. This is because they knew the prosecutorial mind can make anything seem guilty. This is why lawyers always say you should never talk to the police and you should never testify at trial. And the fact that you didn't talk to the police or didn't testify at trial cannot be used against you. It's the prosecution's burden to prove the charges, every element of the charges, beyond a reasonable doubt. It's their burden. And really, by the defendant talking, you can only help them prove their burden, not disprove your case. Never go pro se, hire a lawyer. Okay, let's jump into it. Mr. O'Neal is being charged with killing his wife and his daughter and attempting to murder his son. His son, who is 11 or 12 years old, is apparently going to be testifying at the trial according to this little snippet.
The evidence is going to show that we are under some of the most vicious, lying, fabricating, fictitious government you ever seen. By the time it's all said and done, you will see who is the mass murderers in Tampa Bay, the state of Florida. You will know why what occurred on March 18, 2018 occurred.
Okay, that was fairly interesting. The audio clearly isn't that great, so bear with me. But that was an interesting start to an opening statement. Remember, opening statements are not arguments. You always start opening statements with something like, "Ladies and gentlemen of the jury, we believe the evidence will show the following," and then you proceed to share the evidence that you believe will be introduced during the case in chief. So point to the defendant for actually starting out that way. And it's important to start out that way, because if you don't say "we believe the evidence will show," well, then you're stating it like it's already fact, and that's reserved for the closing arguments. I do have some concerns on the tone he was using, but let's see if he was using that for some sort of dramatic effect and how he continues the opening statement.
And the evidence is going to show that law enforcement tampered with evidence to meet their such high burden of proof. Because originally, it wasn't enough. So we had to tamper with evidence. Since it was such evident already, but we still had to tamper with evidence.
So far, the defendant is being borderline argumentative. Not really borderline, he's being argumentative. The prosecution could stand up and object to keep his opening statements as opening statements and not arguments, but I anticipate that they have no intention of doing that, because the risk of going pro se probably means that you might inadvertently say something self-incriminating, and the prosecution is not going to stop you from saying that, unless his opening statement gets really, really out of hand, which it might.
The evidence is going to show my son did not see me murder his mom. The evidence is going to show he did not see me shoot his mom. wrong. The evidence is going to show my son said many things that are not true. The evidence is going to show that I called 911 during Kenyatta Barron's 911 call. But all of a sudden, it ends up after I called Kenyatta, after Kenyatta Barron's call was made. Now I'm calling 911.
The defendant is using the evidence will show too much. The evidence will show X. The evidence will show Y. The evidence will show Z. He's using the phrase the evidence will show as a crutch. He's using it as a pivot to go from fact to fact that he thinks is going to help him. But quite frankly, the biggest mistake the defendant is making right now, other than actually representing himself pro se, is being too emotional. One of my mentors, who's actually one of the best trial lawyers in the entire country, once taught me that you should never be too emotional during a trial. It's actually really disrespectful to jurors. Jurors are regular people. They are smart. They can see through the BS. And if you're too emotional, you run the risk of coming off as fake or manipulative. You are trying to get their sympathy in order for them to give you what you want, when that is not the case. All you want is a fair shot. You want people to use their knowledge, their common sense to lead you to the desired outcome of the case, and you risk everything if you get too emotional. And as many of y'all know, I am a catastrophic personal injury lawyer. And in my field of law, we really have to watch this. I mean, I deal with people who are burned head to toe, who are paralyzed, who have lost a limb, whose loved ones have died. And when we put these people or their loved ones up on the stand, we really need to be careful we don't overuse emotion. And we play to this. We'll argue, ladies and gentlemen of the jury, we're not asking for your sympathy. We didn't have our client, the plaintiff, get up on the stand and cry and tell you how hard their life was. We told you the facts of how hard their life was. Our client didn't cry and say she cries every morning before she goes to work. She told you how hard it is to get up out of bed and go to work. And it's up to you to use your determination on how difficult it is living in her shoes and how she should be compensated. We are not asking for your sympathy or your pity. We are asking for your understanding. And that's the biggest threat right now to the defendant's opening statement. If he keeps on this real high intensity track, he risks losing all credibility, which will then hurt him for the rest of the trial.
But originally, I called 911 without even knowing she called 911 during her call. But the evidence is going to show that your representatives and law enforcement, local law enforcement, wanted to make it seem like I'm some kind of menace to society. And I ran after killing Kenyatta Barron, knowing that authority was on the way to kill my own children. I wonder why I would do something like that for no reason. And I'm standing here competent as can be, representing myself today. Remember, I told you the evidence will not show you that my son witnessed me beat his mom to death, nor did he witness me shoot his mom. In fact, he didn't witness much at all. And the evidence will show that my son said my dad shot my mom. It's the correct statement if you want to cite statements, if he even said it. Because I can guarantee you, the evidence is going to show you we are under the most corrupt administration you've ever seen in your life.
Okay, so at this point, the defendant is saying that his son, who is going to testify later in this trial, is not correct. The defendant doesn't really provide any explanation for this other than the son is not correct, and the evidence is going to show he is not correct. But remember, the son testifying is also evidence. So if the son testifies that the father did in fact shoot him, well, that is evidence supporting the contrary to what the defendant is saying. And again, the problem with taking such a hard line on a whole bunch of things is it only takes for you to be wrong about one for your credibility to be ruined. And to be fair, maybe I wouldn't have picked up on this had I not peeped this little gem when I was about to watch this video, and it says, "You stabbed me. Boy tells father at double murder trial." The defendant is losing credibility very, very fast.
I guarantee you I wouldn't waste your time. I would have already took a plea deal of some kind if I knew I did something like this, because most people don't even go to trial when they know they've killed somebody.
Ah yes, the classic defense of, would I be going to trial if I was actually guilty?
Had several medications and drugs such as morphine in her system. The evidence would show she had a domestic history with my other child's mom, and about the fact that we had to be cordial for our newborn son. And the evidence will show that they had been going back and forth and arguing on Facebook and by telephone that whole afternoon before the incident. The evidence will show that me and my son was at my mom's house while I was putting brakes on my aunt's car. When we came back home, I never knew she was arguing with my child's mom, my other child's mom, the whole day. That's what the evidence will show. Evidence will show that my daughter was prematurely born. She was autistic. My son Ronnie was diagnosed at the age of 3 with developmental delay and had the history. In this trial of the next one, I can guarantee you that. Because like I said, I look alone, but I'm backed by a mighty God. And ultimately, it will show that none of the state's witnesses can draw any conclusions, especially because they didn't see anything that refutes my self-defense claim and theory. And nor can the state do so beyond their very reasonable doubts that will be revealed. The very reasonable doubts that will be revealed by me.
Okay, I can already tell I'm going to jump cut a lot from that because I didn't really stop it too many times because I don't really think that there was that much to add. I think it's fairly demonstrable that the defendant didn't really give too good of an opening statement. I think he has lost a lot of credibility in the way he gave the opening statement. And I really, truly believe this stems from representing himself. Y'all, lawyers don't make this stuff up. We are here to preserve your rights. Okay? Everybody has rights. Guilty, not guilty, doesn't matter. You have rights. The government has the burden of proof to show beyond a reasonable doubt that you committed the crime alleged. I mean, come on, y'all. I'm trying to be nice because this is a no-win situation, because if he's guilty, he's allowing more things into the trial that would otherwise not be in had he had a lawyer, and if he's innocent, he is making himself seem guilty. Not everybody can be the legal savant that Tim Heidecker is. hire a lawyer. Hire a lawyer. Hire a lawyer. Never represent yourself. If that's the one thing that you've learned from this video, thank you very much. And that's it. All right, y'all. Talk to you later. That was interesting. See you soon. Bye.